the response, then I know you're familiar with the issues, but this is a medical malpractice case involving a surgery that was performed in August 2016 at Texas Health Arlington in Tarrant County. It's our motion to transfer venue to Tarrant County from Dallas. All parties involved in the case reside or have a principal place of business in Tarrant County, and plaintiffs have chosen Dallas County based on the business office of defendant U.S. Anesthesia Partners, where no clinical care is provided. Dr. Paris, the only physician defendant, lives in Colleyville, which is in Tarrant County, and his address is not in dispute. That's where he was served with the lawsuit. USAP has clinical offices in Arlington, Carrollton, and other places, and this business office in Dallas, which plaintiffs did file evidence demonstrating that they do have an office in Dallas, and we're not disputing that. However, our motion is more based on forum nonconvenience. This is, again, all of the care in question occurred at Texas Health Arlington. The plaintiffs themselves reside in Tarrant County, and for the convenience of the parties and all the witnesses involved, we are moving to transfer from Dallas to Tarrant.
Ms. Carboy?
Very briefly, Judge, we've already completed all of the party depositions, including the defendant anesthesiologist. And in fact, we had that deposition in Dallas at defense counsel's office. So they, by consent, that's where they wanted it to take place. And of course, defense counsel is in Dallas. My office is closer to Dallas than to Tarrant. So obviously for financial issues on convenience, we definitely prefer Dallas. We're pretty much just at the plaintiff's expert's deposition has already been taken. We're pretty much near the end of the road in terms of discovery on this case. So I don't think convenience weighs at all. The only thing we've got left basically is a trial. And the distance between Dallas and Tarrant, which of course I'm sure Your Honor knows is just a tiny bit over 30 miles, which we filed Exhibit A9 to prove that up. The defendant has not met its burden to show that the factors that are set forth in CPRC 15.002, convenience and justice to the defendant, balancing of the interest and no injustice to any other party. So of course we filed this case in Dallas, and that is plaintiff's choice under In re Masonite and the Wilson cases that should not be disturbed unless the defendant can meet its burden under 15.002B, which it has not done.
All right, the court is going to go ahead and deny the motion to transfer venue. When are y'all set for trial?
That is an issue, Your Honor, because we have a mediation scheduled in this case, and to try and conserve some of the resources, we've held off a little bit on depositions, but our mediation is like in coming up next month. So we will be asking for a continuance of our trial setting that is on.
The mediation is October 7th and trial's October 20th, if I'm not mistaken.
Yes.
I don't have any problem. I mean, the case is not super new, but well, it's getting kind of old, but the first date I think that we realistically might have juries is November 11th, at least in the 68th. And so I don't think there's any way we would reach you anyway. I don't mind moving you to November 11th, but it would be a Zoom trial, which I don't really want to start off with a med mal case on Zoom. The first Zoom trial will probably be a car wreck. And so, but if Ms. Carboy or Ms. Aceta, if you'd really like to be set on November 11th on the Zoom docket, we can do that and just kind of figure out if the case will go. But I don't know that I want to have the first Zoom trial on being a case of this complexity. But if you guys really want to, we can work it out.
Is there any chance of having in-person trials coming up, or is that just not on the table yet?
I don't know. We're, in Harris County, they're going forward with in-person trials. and Bear and Travis, they're going forward with Zoom trials. It appears what we're doing, although this is, changes day to day, is that we're going to do kind of a hybrid. We're going to start Zoom trials, I think, on November 11th, if we can get all the technical issues worked out. And then just kind of do those until we can do live trials, I think, is kind of the plan. My thought at the moment, and again, this may change tomorrow, is for those who will agree to a 6-person jury, I'm probably going to be more likely to do those live. For those who are insisting on a 12-person jury, I'm more likely to do those on Zoom. So, but either way, I just don't think that this case is right for the first docket's going to be on November 11th. I just don't think this is the right case for it, but I don't know all the details, and you guys are both experienced counsel. If you really want to be set on the Zoom docket for November 11th, I'm perfectly happy to do that. We just will have a lot of logistical issues we need to work out.
We'd probably, the plaintiffs would prefer probably just a little past that date. So
Okay.
the court can work out the
I think that's wise.
Would you like us to submit an agreed scheduling order?
Either way, I can reset it now if you want, or if you want to do something else, we can do that as well. I'm happy to do either.
Well, what do you think?
If it's,
check with Bill.
I think we probably need an opportunity to just confer. I'm sure we can come up with an agreement, but I know it would be defendant's preference not to do a Zoom trial, Your Honor. But I think we can work with Ms. Carboy and submit an agreed scheduling order here pretty soon.
And the other thing I would say is, I know that defense bar is not super excited for whatever reason about doing 12-person juries, and so, or doing 6-person juries, but at least in my opinion, and I'm not speaking for all the judges, but I just don't see how you can safely do one of those during the pandemic. And so if you guys are going to insist on a 12-person jury, it'll probably be on Zoom until the pandemic's over. So that's something you're going to talk to your client about.
I will, Your Honor. I made some notes and we'll be discussing that and we'll take that into account. I appreciate all those details. That's very helpful.
And again, it may change tomorrow. So, that's kind of how things have been going here. But we have just in full transparency, we have a judges committee that has been appointed to come up with a jury trial plan, and the plan hasn't been adopted yet. We're still working on the details. We have a meeting later this week, and there's going to be a portion of the plan, I think, that's going to cover live trials whenever those occur, and then there's going to be a portion of the plan that cover remote trials. We're going to use, I think, something that's similar to the Austin model for remote trials, I think. But all of that's very much up in the air. So at this point, you guys are still, you're still on the docket for October, whatever it is, 20th. There's no way that I can see that we would actually be able to go that day. The earliest possible date would be November 11th. And that is, only a possibility. We're really trying to work out these technical details right now. So, and again, I'm happy to move you guys well past that if you're, sometime into 2021. But just be aware that once 2021 hits, you're either going to, if we can do 6-person trials, I'd prefer to do that. If you're not willing to do a 6-person trial, then I'm intending to do those on Zoom.
Thank you very much, Ron.
Thank you.
All right.
Thank you,
guys. All right. Bye-bye.
Bye. Thank you.
Okay. Marsh v. North Texas Contracting. That's a continuance. I see Mr. Wiseman here. I think I see Mr. Mayo. If you want to go ahead and turn on your, both of you unmute and go ahead and turn on your video as well.
Hey, Judge Hoffman. Nick Wiseman for the plaintiff. I think Mr. Marsh is here. I saw him here a minute.
I see Mr. Mayo here. Oh, is that the
Mayo? That's what I meant. Yeah. But I
don't know what he's doing. He needs to unmute.
Yeah. Okay.
It looks like he unmuted. Mr. Mayo, are you there?
I am here. I apologize, Your Honor.
That's okay. All right. You guys are here on a continuance motion. When are you guys set for trial? I know it's coming pretty soon.
I want to say, I'm sorry, Judge, I just had it up. I want to say it was December. It was either, the motion itself says September, but I believe it might have even been December. I know that I need about 6 months to get everything together. We've done some paper discovery. There's a motion to compel on file. Haven't taken any depots except of the plaintiff.
Okay. The case, is relatively new, so,
Right at a year.
Mr. Mayo,
Yes, Your Honor.
do you know the trial setting?
The current trial setting, I believe, is the end of September. Hang on just 1 second and I can tell you.
And you probably, did you guys?
September 29th of this year, Your Honor, is the current trial setting.
So you guys heard what I told the previous folks. So the earliest we could realistically have any chance of reaching you is, okay. Realistically reaching you would be on November 11th, but I think that's a bit of a long shot. I don't know much about this case, so.
It's 2 motorcyclists that went into a construction zone and were injured.
Oh, okay.
It's not a simple rear ender. There's a little bit more to it.
Okay. According to my having some computer issues here, sorry. According to my court coordinator, this case is set on December 8th, but
Right. There was that motion for continuance. There was a misprint or just a mistake on the title of it. I believe you had earlier changed the 29th date to December. I think you did that back in February.
December 8th. So do you still want a continuance, or do you?
We're not going to, I don't think we're going to make it. I mean, I don't think we need it. I don't think we have to have it right now, but I think we might as well just do it, Your Honor. That way, I think it'll be a more stable date and more realistic date.
Okay. When do you want to be reset to?
I believe that there's an attached ASO that has a proposed date.
The proposed date is June 7th, and I think, if I'm not mistaken, Nick, you had cleared that with the court.
I
Is
hope
that a
so.
Tuesday? And you said there's an ASO on this as well?
There should be, Your Honor. There is on mine, at least what I have that supposedly we sent you.
Let me see.
June 7th is a Monday.
Okay, so it'll be on June 8th then. When did you submit the agreed scheduling order?
On August 14th.
I see an agreed continuance order. I don't see a scheduling order.
It was attached as an exhibit to the motion for continuance, I believe.
Oh, okay. That's.
Yeah, I'm looking at it right now, Judge. I can email it to you if you don't have it.
Let me see if I have it. Let's see. Okay. That's not how we usually see it, but that's okay. I'm going to go ahead and print this out, Rhonda, if you can bring it to me. All right, June 8th at 9 a.m. Hopefully by then the pandemic will be over and we'll be able to go back to normal. But as you heard, if we're still in the pandemic, my intention is to do either 6-person jury trials in person or 12-person Zoom trials, but that's a ways off. So we'll see what happens.
I have no problem with 6 people.
But something you might want to talk to your client about, Mr. Mayo.
It is.
Okay, that's a ways off. Hopefully everything will be fine and you won't have to worry about it. So, all right, thank you guys.
Thank you, Your Honor.
Have a good day.
You too. Okay, do we have anyone here on Arnold v. Pena? Arnold
Yes,
v.
Your
Pena.
Honor.
Okay,
Yes, Your Honor.
Yes, Your Honor. This is Anna Lee for the plaintiff's attorney.
oh, great, okay.
And Fernando Martinez again for defendant.
Good to see you, Mr. Martinez.
And Laurel
Okay.
Engelman for the defendant Shaw.
All right, so you guys are moving for continuance as well?
Yes, Your Honor.
So when are you currently set?
We're currently set for October 13th. And we have deposition hopefully in November. We're gathering dates and hopefully finalizing that today with the mediator's office.
Okay,
And
one
of the plaintiffs recently died, Your Honor.
oh, I'm
She-
sorry to hear that.
She did in April of this year, and we filed a suggestion of death, and her daughter will be taking over. We don't anticipate that being an issue, but we filed that last week.
Okay, so when are you guys wanting to be reset to? The earliest, I don't know if you guys were on the phone, but the earliest would be November 11th. Did you guys want to try to, that's going to be a Zoom docket. I know that's kind of quick and it sounds like you have some depositions, or I don't mind moving you a little bit later, or what is your?
I think it would be better to move us to either December or January, Your Honor. Do y'all
Okay.
agree with that? That's fine with me.
Yeah, my thought was early 2021. We could be either good to go or have it wrapped up.
And just be aware, I think you heard me probably talk to the other attorneys, at least at the moment, my plan is, if possible, either to do 6-person jury trials. If people insist on 12 people, then I don't see how you can safely do that in our courtroom. So we're probably going to be doing those on Zoom. So you may want to talk to your clients about whether or not you want to do a 6-person in person or 12-person Zoom. It's, again, things are still up in the air. There's no certainty on this, but that's kind of my current plan. But you don't need to make a decision right now.
Okay.
Appreciate that, Your Honor.
Okay. So what day did you guys want to reset this to?
I think maybe in January would be a good date if it's far enough out to where it may not conflict with our calendars. Yeah, like the week of the 11th or the 18th or the 25th.
We have special settings pretty much every week in January, so I would suggest maybe February.
Okay, how about February 1st?
Yeah, I'm totally good with that.
So we have February 2nd, 9th, 16th, or 23rd. We do trials on Tuesday.
The 2nd is fine with me. Me as well.
Yes, also clear.
All right, so I don't, let me see, this is on the Arnold case. Okay, yeah. Miss Lee, can you go grab, I just printed out an order. Can you grab it from Rhonda? Okay. We'll go ahead and set that then. Just make sure that you have the, kind of technical expertise to do this on Zoom if you're going to want to do a 12-person jury. So, but hopefully by then we'll iron out a lot of the kinks. So,
Out of curiosity, Your Honor, the ones starting in November, are those going to be broadcast and kind of maybe we can learn from other people's?
yeah. So
experience?
if it happens, and we're still working on technical details, we're trying to follow kind of the Austin model. We're looking at November 11th, and it'll be on YouTube.
Cool.
So at least that's the plan. We'll see how it goes. I mean, I kind of feel like if Austin can do a jury trial in August, surely by November, Dallas can. So, but we'll see. And we said the 2nd of February. Okay. Okay, guys. You be safe, okay?
Thank you,
Thank you,
Your
Your
Honor.
Honor.
You too.
All right. Bye-bye.
Bye.
Bye-bye.
Ralph Lubin's Time versus Richmond Trust.
Good morning, Your Honor.
Mr. Tobolowsky. Ms. Compton, are you there? I think I see you. You're
Katherine.
muted.
I'm here, Your Honor. Good morning.
Okay. And what we have set today, I think, is a motion for partial summary judgment, a motion for leave, and it says here also, I didn't know this, a motion to strike and for sanctions. Is that set for today?
That is, I believe, a part of the plaintiff's objections to the defendant's summary judgment evidence and a motion to strike that evidence along with, I called it a motion for sanctions, but it's for the recovery of fees and expenses under 166AH for filing bad faith declarations.
Let's go on the record on cause number DC 1915404, Ralph Lubin's Time versus Richmond Trust. Counsel, make your appearances.
Michael Tobolowsky on behalf of the plaintiffs.
Katherine Compton on behalf of the defendants, and my client, Mark Richmond, is here today on behalf of himself and on behalf of Richmond Trust. And Your Honor, I also have sort of a list of each of the things that were filed in the order that they were filed, if you would like for me to go through those for the court's convenience.
I've read the summary judgment and I've read the response and I've read the reply. And I think I've read the motion to strike. I don't honestly recall. There was a ton of briefing on this. The core issue here is the summary judgment. All the other stuff I think is somewhat superfluous. And so let's talk about the summary judgment first off. What I'd like, Mr. Tobolowsky, for you to do is you do a summary in your briefing about what each of the deeds provided, like a 1/6 share, 1/6 share, 1/3 share, 1/3 share. The briefing was about 900 pages, if I recall, total with all the attachments. I couldn't find exactly where you were citing to within the summary judgment evidence. And so if you could bring up that page and then also bring up each of the different deeds that you're relying on, that would be very helpful.
I can do that, Your Honor. And would you like me to pull them up on my computer and share the screen? Is that the easiest?
Yeah, that's what I was suggesting. Right. And let me tell you why I'm doing this is my inclination is to enforce the deeds as written, but I wasn't really sure how the deeds were exactly written based on the briefing. But assuming that they say what Mr. Tobolowsky said, my thought was, at least my inclination is at this point, is to enforce the deeds as written.
And Judge, just as I'm pulling it up, I will let the court know. I've got copies of the deeds in two places. They are attached as certified copies as required, but then they're also attached to the stipulation that the parties entered into, stipulating that those are the correct deeds. and that they are the deeds that determine.
However you want to show it to me. Is there a stipulation that that's what the deeds,
There is, Your Honor. It's Exhibit B to.
you want to show the stipulate, whatever's easiest.
I've got I've got one of the first certified copy. I'll go ahead and show the court now.
And Your Honor, there's also in the Liz pendants, in the stipulation, evidence that we filed a Liz pendants for the equitable title, which under the law would control over record title.
Okay, Your Honor. So what we're looking at now, can you see my screen?
Mm-hmm.
Okay, this is Exhibit C to the plaintiff's response and cross motion. This is the deed to the first of three properties, Record Street.
Okay.
And I'll pause here.
I want to see where the,
It's
Okay.
easier if I go to the second deed, Your Honor, because it's specifically set out.
well, I want, each deed is is different, right?
Correct. That's right, Judge.
So can I see can you, I
Yeah,
apologize. Can you move back to where you were on the first deed?
I can. My apologies.
And again, if there's a stipulation to this, that's okay.
Okay. And there is, Judge. That's Exhibit B. And this is the Record Street property.
Okay, so let's see, that it says that Frank Benson here, who is Frank Benson?
Frank Benson was the grantor or the seller of Record Street back in 1964.
So he's the previous owner.
Yes, Your Honor, he is.
Okay. And then he conveyed it to the Judith Richmond Trust, the Judith Richmond Trust number 2, the Harvey A. Richmond Trust number 1, the Harvey A. Richmond Trust number 2, and then the Mark Richmond Trust number 16. Okay. All right. So what about that was confusing? I'm not sure. You said that there was something confusing about this. So what is?
Not that it was confusing, Your Honor. It's, as you'll see, the second property identifies these interests in a separate paragraph as well. And it's just very easy to immediately look, see, and identify what interest each person got. That's all I was meaning.
Okay, let's go to the next one.
Okay. And the next one is Exhibit D to plaintiff's response, and it pertains to what we've referenced as the Greenville Avenue property.
Okay. That's easier to read.
Only sorry, I get not the quality, I suppose, Your Honor.
Okay.
At the bottom, it says, it is understood and agreed that the undivided interest of the several grantees will be as follows. And then it
Okay.
identifies each of them.
Okay.
And the plaintiffs are the heirs of Judith Time. Okay, and then the third deed is Exhibit E to plaintiff's response. It pertains to the Richmond Street property. And all right, let's see right there.
Okay. And is this the third one?
Yes, Your Honor, it is.
Where is this? I don't see, maybe I'm missing it. Where does it show the distribution?
So right here, right here, Your Honor, have granted, sold, and conveyed, and it lays out each of the individual grantees right here.
But it doesn't say what their percentage is, or does it somewhere?
Make sure that's not on the second page.
Is there somewhere that shows what the percentages are? Because this just shows who the grantees are.
It just says who the grantees are, Your Honor, but, and I believe this is also in the plaintiff's response. The presumption when property is deeded this way is that each of the grantees is a co-tenant. and takes an equal undivided interest in the property.
So on this one, though, well, this doesn't even say who it's granted to, right? This is said who's paid by.
And then the granted to is right here.
Okay. So Joseph Richmond would get 1 share. Okay, it's hard to, is he trustee of the?
Of the 2 Harvey Richmond trusts and the 2 Mark Richmond trusts, but then you see Judith Time individually.
So is it your argument they each get 1/3, or Judith Time got 1/2 and the other one's got 1/2?
The plaintiff's argument is that Judith Time got 1/3, and then each of the trusts got 1/6, but that because each of the siblings have 2 trusts, ultimately they end up holding 1/3.
Okay. Okay, that kind of answers my first question. All right, well, that clarifies that. Let's go ahead and go forward then. What else did we need to talk about?
Your Honor, do you want me to respond to that specific issue, or do you want us to make?
I mean, at this point, I'm strongly inclined to rule in that way. So if you have some reason for me not to, I've read everything. I don't know that you can say anything to persuade me otherwise, but maybe there's something I'm missing. That's why we have oral argument.
Thank you, Your Honor. Your Honor, basically what the plaintiff is saying is that record title is record title, and there's nothing else that you can look at other than the 4 corners of that. That is not what the case law says. When you have equitable title trumps record title. And there's specific case law we cited in our brief. I believe it's Mann versus Gann. I'll have to look at it. It's cited in our brief that parole evidence is allowed when you're talking about equitable title. And in this case, if you looked at the theory of partnership law, properties were put because of the aggregation theory, then revolving into the unity theory. Those properties were put into the individual names because back then you really couldn't put property in a partnership name without the risk that it would be treated as a corporation. So as time evolved, then the property was put into the name of Richmond Trust. However, I mean, this is very clear law on equitable ownership trumping. And if you look at, and I have a PowerPoint prepared that can show you the direct testimony of every single plaintiff where they say, did Judith Richmond pay any of the leases? No. Did she get any profits directly from it? No. Every single indicia of ownership was in Richmond Trust properties. Those properties have been run by the partnership for 48 years. And so to now say, oh, well, these are lucrative properties, based upon the 4 corners of the deed, this would be contrary. I'm not trying to be disrespectful at all to the court, but I'm saying this would be contrary to the law that we have cited. And it's the Faust case, the King versus Evans case. This case is the Siller case cited by Mr. Tobolowsky, only a part of it. But all of those cases say you look at the evidence of intent of the partners as to ownership. And Richmond Trust is the only one that paid the bills. They leased the property in the name of Richmond Trust. Every single, and to the contrary, you can see from the testimony of the plaintiffs, there's not one piece of evidence that they did anything to use or any indicia of ownership of those properties that were in Richmond.
So Ms. Compton, let me make sure that I'm fully up on kind of, because we had a bit of, I know, some arguments about this. So the summary judgment today is your summary judgment, correct?
Yes.
And so I really can't rule today that the deeds, because we're not hearing Mr. Tobolowsky's client summary judgment until for a couple of weeks, I think, right?
25th.
So to me, I think this is a fairly easy decision, which is I'm going to deny the summary judgment. The more difficult issue will be, I guess, with Mr. Tobolowsky is do I just rule in his favor and say that we're going to go by the deed, or is there a fact issue here as to whether or not there should be some type of equitable title? I cannot imagine a situation that I would rule on the summary judgment in your favor. I can see that there could be a possibility that I might deny Mr. Tobolowsky's summary judgment if I, am willing to consider this parole evidence, but I cannot see a situation where I would grant your summary judgment. But go ahead.
And Your Honor, I would also ask that, based upon the record, that we had a motion for leave, because this will be a point for an appeal, because this is black letter law in our opinion, and with total respect to the court. So we would like our motion for leave to admit the evidence. Actually, this is only for purposes of our summary judgment, but our summary judgment's important. We would like our motions for leave granted so that that's part of the evidence.
I'm going to go ahead and deny it, the motion for leave at this point, unless you want to agree, Mr. Tobolowsky.
No, I was going to object, but I'll be quiet, Your Honor. Yeah.
So I'm going to deny that. I'm not going to award any attorney's fees on this. I really think that you're going to have time to include this evidence in responding to Mr. Tobolowsky's summary judgment. There is no appeal of a denial of summary judgment unless there's some new law that I'm not aware of.
Not at this time.
Yeah, so since I'm going to deny the summary judgment, I don't see any reason to grant the motion for leave at this point. But that doesn't keep you from providing the summary judgment evidence in response to Mr. Tobolowsky's, and I'd encourage you to do that.
Okay. Thank you, Judge.
Anything else we need to chat about, guys?
I think that takes care of the rest, Your Honor.
Mr. Compton, was there anything else you wanted to chat about?
No, Your Honor.
Okay. Mr. Tobolowsky, can you prepare a order for me on all of this? And again, I'm not awarding any type of attorney's fees. And I want to make it clear that, Mr. Tobolowsky, that I don't want you to represent to your client. I don't know if your client is here today or clients are here today, that I'm going to grant the summary judgment in your client's favor. But I just don't see how I could grant it in Ms. Compton's client's favor. There may be a fact issue as to whether or not there's some equitable title that may exist. But I just don't see granting a summary judgment on that for Ms. Compton. So there may be a fact issue, there may not be a fact issue, but at least at this moment, I'm kind of inclined to award this as per the deed, but we'll see kind of what the next summary judgment hearing holds.
Your Honor, there was really 3 issues in our summary judgment. One dealt with their claim of tenant in common, which you obviously are in favor of just looking at the 4 corners of the deed, which we obviously disagree with. But the second point was that they're claiming that they're also partners in the partnership, and we feel strongly that that evidence is not supported either. And so we would ask that you grant our summary judgment in favor of the fact that they are not partners in Richmond Trust.
I do think that's probably true, Mr. Tobolowsky.
Yeah, Your Honor. I've obviously our response is briefed in a very lengthy way, but there are actually a handful of reasons that prove the exact opposite, that the facts do not dispute that the plaintiffs were accepted as partners. And so the claim that is really at issue in this part of the summary judgment is plaintiff's declaratory judgment claim, which falls into 3 separate requests. 1, a judicial declaration that an assignment, which was signed by the managing general partner of the partnership, accepting and acknowledging that the plaintiffs were indeed general partners of the partnership, it is a valid and enforceable assignment agreement that says what it says and proves that the plaintiffs are partners. That's the first reason. There is endless amounts of evidence, Judge, that prove that assignment did exactly what the plaintiffs just claimed. And that would be 10 years of Schedule K1s being issued to the plaintiffs, specifically identifying them as owners and general partners of the partnership. 10 years of Texas franchise tax reports with the Secretary of State of Texas saying the exact same thing. 10 years of email correspondence specifically asking the plaintiffs to opine on actions that the partnership was taking. It didn't, not until 2015, 2016, when the parties really started getting into a family dispute over how to manage the partnership, did the defendants first start claiming, oh, you guys actually aren't partners. The plaintiffs don't dispute that the defendants could have taken that position when Judith Richmond passed away. They just chose not to. Instead, because it's a family and a family partnership, they chose to admit their sister Judith's heirs as partners, and they did. All of the evidence supports it. Most importantly, the assignment agreement memorializes it. The consent that the defendants provided, granted, was not in writing, but that is the exact reason why the plaintiff's attorney at the time suggested that the assignment agreement be executed. And the position that the defendants are now taking is that the assignment agreement transferred a creditor's redemption interest. That is not mentioned anywhere in the assignment. It seems somewhat preposterous that that's what the assignment agreement would have been doing when it specifically states otherwise. And it is also evidence that that assignment agreement is signed by Mark Richmond, quote, as general managing partner of the Richmond Trust Partnership, which he testified at his deposition, and this is also an exhibit to our motion, that he would get the consent of his co-partners, and then if they all agreed, he, on behalf of the partnership, would go take the action necessary, be it sign an assignment agreement or sign a lease, etc. He was always the individual who signed for the partnership, and the partnership only signed after the partners agreed. And so there is mountains of evidence, and that's part of the reason why the plaintiff's response was so long, that proves the plaintiffs are partners. But on top of it all, Your Honor, there's been evidence and testimony from the defendants, from all parties, that the individual who really set this partnership up is the patriarch of the family, Victor Richmond. That's Judith Richmond and the defendants, Mark and Harvey Richmond's father. And he set this partnership up, which is why he's the one with all of the knowledge. And since we don't have documents, as testified by Mark Richmond, that go back that far, the best we have to do is rely on the docs we do have. And fortunately, one of those documents that was produced by the defendants is a letter written by a letter written by Victor Richmond, where he specifically states, and if it's okay for the court, I'd like to just pull it up really quickly, right here. So, Your Honor, this is a letter on August 12, 1982, from Victor Richmond, where he specifically states, the new owners, Richmond Trust, is merely a convenient trading name, or trading label for Mark H. Richmond, Harvey A. Richmond, Judith S. Time, and their minor children. Their minor children are the plaintiffs, Your Honor. And so if there's any dispute about whether the plaintiffs became partners after Judith passed away, there's certainly no dispute that they were always intended on being partners and that their interests were merely being represented by their mother, Judith.
So correct me if I'm wrong, if Judith Time was a partner and she passed away, the minor children do not become partners, they become creditors. Is that correct?
That is correct.
If, Your Honor, one, they were not already partners, which Victor Richmond, who set up the partnership, is indicating here they always were. And two, if the defendants didn't consent to allowing the plaintiffs to become partners. And I know that right now in court, they're taking the position that they never consented. But then there's at the very least a fact dispute. Then why were 10 years of K-1s sent? Why was the assignment agreement signed?
The
And why-
K-1s were sent to Judith Time or to the children, her
To the-
children?
To the plaintiffs, Your Honor, and the exact percentages identified in the assignment agreement. They
All
are
right.
there. Yeah.
Response to that?
Yes, Your Honor. Clearly, the heirs are not partners in trust. And I think that you were leaning in that direction. As you know, under the Texas Business Organizations Code, under 152-501B7, if there is no partnership agreement at the time of the death of Judy, she automatically withdraws from the partnership and the heirs become creditors. And in this case, it is undisputed, there was no partnership agreement. Thereafter, 16 months later, and Yolanda, I may have you pull up the language from Ralph, where he testifies about, where he states in a document about the meaning of the assignment. So basically 16 months later, the assignor, who is Ralph as the executor of the estate and Ralph as the trustee of the 2008 revocable trust, creates an assignment document to the heirs. And the purpose of this document, according to Ralph, was to just change the money so the money didn't have to come to the estate, to the trust, then to the heirs. It could just go directly to the heirs. That was the purpose. And that's what this email that Yolanda can pull up. It's Brenda Time Bates number 805, where he says in 2013, I basically don't think that's what this means, but we can certainly check and see. I don't think it has anything to do with making us partners. Nonetheless, in order under the code, the Texas Business Organizations Code, which is all that applies when somebody dies and there's no partnership, each of the partners have to consent to letting somebody in.
Go ahead and show me the email so I can see what you're talking about.
Yolanda, can you pull it up? See if she's there. She might be looking for it. Yeah.
Give me just a minute and I will pull that.
Okay. I can tell you what page it's on. Keep going.
Is this the email?
No.
Oh, I'm sorry. That's me, Your Honor. That was the assignment. I apologize. I didn't know that was coming up. I thought I was just looking at it.
It is on page 26 of our PowerPoint.
It sounds like we're having some technical difficulties. I'm not inclined to, why don't we do this? Why don't we carry this issue to the next? Okay.
Here we go. She found it.
Okay.
So this is in 2013. And you see the highlighted language from Ralph to Brenda and Robin in 2013 saying, I'm pretty sure this only formalizes the distribution of mom's interest in these partnerships to the heirs and doesn't actually have any bearing on creating a partnership. And clearly that's what the intent was. And that's what they told Mark. And Mark is not a party as an assignor or an assignee to this instrument. And also there is no authentication of the assignment that they've tried to put into evidence. So it is not evidence in the case. But nonetheless, what the Texas Business Organizations Code says is that to allow somebody in as a partner, it doesn't matter if you've shared documents with them or anything like that. What matters is that Mark Richmond and Harvey Richmond, the two individual remaining partners, had to actually consent. You have to consent to let somebody in. Harvey is nowhere on the assignment document, and Mark individually is nowhere on the assignment document. At the very end of the document, it's saying that the Richmond Trust acknowledges this, what's happening here, but that's only, they're going to change the way payments are made. It has nothing to do with the acceptance of new partners, which would be a big deal. There's no case law cited that the partnership can accept new partners. It's got to be the individual partners. So, you know, what they're trying to do is get, you know, a hold of some valuable property through this lawsuit, and then also claim that they're partners. And there's just no evidence that they're partners. And the CPA also testified, that's Kathy Quinn, and they've attached her deposition to their objection and response to our summary judgment evidence. And she basically testifies that Mark, and we've provided an affidavit of Kathy Quinn, that all along Mark has said to the partners, I mean, he said to Kathy Quinn, who was preparing the documents, the financial documents and the tax returns, they are not partners. And what Kathy Quinn said is, if they will not agree to a redemption price, which is all they're entitled to, is at the time of her death, you get the fair market value of her redemption, of the redemption price on the day of her death. That's all she's entitled to. But you can't figure out what that is to create a promissory note or whatever needs to be done until the parties reach an agreement on the redemption price. So all these years since 2008, the parties have not reached an agreement on the redemption price. That's what this lawsuit is supposed to be about. And never once has Mark agreed, or Harvey, that they could be partners. And that's, there's clear evidence of that in the deposition testimony of both Mark and Harvey. And we would ask that you grant our summary judgment that they are not partners, and that the sole issue to be addressed in the next summary judgment hearing of the plaintiffs would be just their tenant in common issue.
Your Honor, may I briefly respond?
You may.
I think it's difficult to sit back and listen to the new positions that have been taken for litigation purposes only. But to say that the K-1s were sent to track a creditor's interest violates federal law and disagrees with federal law. What should have been filed if the plaintiffs were creditors is a form 1099-INT. And ironically, Your Honor, that is what the defendants started issuing to the plaintiffs after this dispute reached its peak. The defendants hired a new accounting firm, and all of a sudden, the ownership interest was zeroed out, and they started receiving 1099s. These are entirely new positions that have just been created. Regarding the consent issue, the statute does not specify that consent must be in writing. And the defendants urged that no written consent was provided because they know that the consent was given orally, and that is why the assignment agreement was executed. So what I had up on the screen, and I will just bring it up very briefly, this is the assignment agreement, Your Honor. And it is specifically stating that Judith Richmond's 33% interest in the partnership is to be distributed as follows. And then for the next 10 years, that is exactly what happens. 1/3 of all of the partnership's profits are distributed pro rata to each of the plaintiffs in those exact percentages. And so at the very end, where it specifically says, excuse me, right here, where it specifically says notice received and transfer accepted, Mark Richmond, general partner. That's why Harvey Richmond's signature isn't there. He and Mark Richmond had already agreed and consented, and so Mark signed. The argument that this document transfers or enables the partnership, is what Ms. Compton said, to pay the plaintiffs is preposterous. An agreement is not necessary for them to pay Judith's heirs in a certain way. They can just do it. Furthermore, they don't know how much to even pay until a redemption amount is agreed upon. So to just distribute 1/3 of the profits every year until forever, unless the plaintiffs were partners, it just doesn't make sense. And the evidence supports that. The final point I wanted to make in response, Your Honor, is pertaining to Katherine Quinn's declaration, which is the subject of one of our objections. And it's a part of the reason we were asking for fees, because the declaration was drafted by Ms. Compton, and it was delivered to Ms. Quinn after speaking with Ms. Compton over the phone. We learned at her deposition, and Ms. Quinn's declaration itself states that it's based on the best knowledge that she has. And Texas law is very clear that the best knowledge is not competent summary judgment evidence. And that's why we've moved to strike that affidavit, in addition to a host of other reasons. But the positions that the defendants have taken are not supported by any of the evidence.
May I have a quick response, Your Honor?
I'm sorry. We're out of time at this point. I'm going to go ahead and carry this issue to the next summary judgment hearing, and we'll talk about it in more detail. I think it's a close call on whether or not there should be summary judgment on this, but since we're going to already have another summary judgment hearing, I'm just going to go ahead and continue it to that one. So, guys, good to see you. Good briefing. Mr. Tobolowsky, go ahead and get me the orders on what I've ruled on so far, and make sure you run that by Ms. Compton. I'll need those orders before Friday. So
I'll get it to you before then. Thank you, Judge.
Thank
all
you,
right.
Your Honor.
Anything else, guys?
That's it.
All right. You guys have a good day.
Thank you, Judge. Bye.
Benedetto versus Mr. Towing. I saw Mr. Melendez here.
Yes, Your Honor. Sorry, I was having a little bit of Wi-Fi issues, but I'm here on behalf of the plaintiffs.
And then is Mr. Reynolds here, Charles Reynolds?
Your Honor, this is Megan Ferris. I'm here for the defendant and for Mr. Reynolds.
Okay. So you were here on the scheduling conference. Have you guys reached an agreement as to their trial date?
No, Your Honor, I haven't seen any 2021 trial dates on the website, but I'm sure we could.
When do you want to be reset to? I'm pretty flexible. This is a brand new case. We can set you next summer. Obviously the pandemic is causing a lot of uncertainty as to trials, but or what, I don't know anything about the case. So how much time do you need to get it ready?
No, I think next summer would be fine. It's not a complex case at all. It's a somewhat of a hybrid auto pedestrian case.
Yeah, next summer, Your Honor, is fine for defense.
All right, let's pick a date in the summer.
Preferably July. June is a little bit busy for Tim. He's got 2 other trials. So July would be best for us.
The 6th, the 13th, the 20th, or the 27th?
The
Let's
27th is the only bad one for me, actually. The others are fine.
Okay. We can do the 20th.
I can
Does
do
that
it.
work for you, Mr. Melendez?
It does, Your Honor. That's a Tuesday, correct?
Yeah, we always do our trials on Tuesday.
Got it. Yes, it does.
We said 7/20/21. And then if you want to get a scheduling order in, you can. The main thing we do these for is just to try to come up with a trial date, but you can work. Is there any big issues? The only thing that I really have any type of preference on is to try to get any dispositive motions heard at least 30 days before trial. So you can include that in the briefing. Other than that, and then Daubert motions, I'm more likely to take seriously if they're filed if they're heard at least 30 days before trial, but we don't see many of those anymore. So anything else we need to chat about?
No.
That's from our perspective, Your Honor.
All right, guys, you be safe out there, and we'll go ahead and reset this set this for 7/2021.
Okay, thank you, Your Honor.
Thank you,
Megan,
sir.
will you send us a draft?
Yes, we'll do a draft scheduling order and send it over.
Appreciate it.
Great.
All right, sure. Thanks.
Thank you, guys. Nemens v. Dart. Anyone here on that case? Wilmax v. First Specialty Insurance Company.
Todd Lipscomb on behalf of the plaintiff, Your Honor.
Raven Atchison on behalf of the defendant.
Miss Atchison, I can barely hear you.
Oh, let me scooch a little closer. Sometimes it's this laptop. Is that better?
Tiny bit. It's very hard to hear you, but was there ever a response filed to this motion?
Yes, Your Honor. It was filed on Friday.
I haven't seen it. The rules require you have to file it at least 3 days in advance. I don't even know that I looked actually on Sunday and I didn't see it.
Check with Daniel. We have a receipt for it, and I got an email on it. Someone's actually filed it for me. I believe it was filed on Friday, Your Honor.
Have you seen it, Miss Atchison?
Yes, Your Honor, we have.
Okay, let me see if it's up now. All right, let's go ahead and go on the record, Tony, on this one. Cause number DC 1918640, Wilmax Capital Inc. versus First Specialty Insurance Company et al. Counsel, make your appearances.
Todd Lipscomb on behalf of Wilmax.
Raven Atchison on behalf of the defendants.
All right, there was a late filed response on this. The court, although the court came in yesterday to do their final reading, I have not seen it. So let me see if it's up now. Okay, it just got posted, I think. So let me see. Go ahead and make your argument.
Would you like to hear from the movement or the respondent?
Yeah, the movement.
Yes, Your Honor, thank you. We're here on an insurance dispute, and we filed a motion to dismiss based on a mandatory forum selection clause that requires the lawsuit to be filed in New York. The short argument is that these clauses are routinely looked at Texas courts all the time. They are presumed to be valid and enforceable, and it's a really heavy burden to overcome that presumption that they are valid and enforceable. There's only two ways to do it. You have to prove that either enforcement would be unreasonable or unjust, or that the clause is invalid due to fraud or overreaching. The plaintiffs have not alleged that there's any fraud or overreaching that's taken place, so we really only have to determine if it would be unreasonable or unjust to enforce the clause. The plaintiff tries to do that by saying that because New York doesn't recognize the Texas Prompt Payment Act, that it would be deprived of its day in court. But there is Texas case law that says just because the contracted for forum does not recognize a cause of action that the pending forum recognizes, that's not enough to overcome the enforceability of the clause. It's also mentioned some arguments about subject matter jurisdiction, but again, general obligations of law 5, section 5, 1402 says as long as the forum selection clause has also a choice of law provision, as this one does, and the dispute is in excess of $1 million, then that is satisfied as well. So that's not an argument that would mean that they're deprived their day of court, making it unreasonable or unjust to enforce. The other argument is the argument about statute of limitations. But again, that's been addressed by In re Lyons and AIU and Chandler Management. All three of those cases support the enforceability of a clause, even if the statute of limitations have run, and even if the pending forum recognizes a cause of action that the contracted for forum does not. The last argument that they've made in their response is that it would result in piecemeal litigation. That argument is a bit unusual to begin with, because they've actually filed 2 separate lawsuits over the same instance. So there's already 2 lawsuits going at the plaintiff's filing of the cases, not at any fault of the defendants. But most importantly, there's case law, the FC Stone case, that says even if it results in 2 different lawsuits, that's not enough to avoid enforcement of the clause either. So in conclusion, we do not believe that they've met their heavy burden to overcome enforcement of the clause, and we think that the motion to dismiss should be granted.
Response?
Yes, Your Honor. I apologize that you didn't get a chance to review this ahead of time, and please don't hold that against Wilmax. I'll try to walk through a little bit of it, because I think some key details about this entire process or about this case have been left out. And these insurers sold a policy governing providing insurance to Wilmax from May 15th, 2015 to May 15th, 2016. And attached to our motion is Exhibit A, and I'll go ahead and pull that up on the screen. This is, if you can scroll down here, confirmation of binder of coverage. And so the whole policy doesn't get sent to you when you first issue the policy. This was issued by a company called Lockton, who's also a defendant in the lawsuit. They're the brokers of this policy. And as you go through this policy, you'll see it starts giving the key terms, how much insurance is involved, the time period of the insurance. And you'll see that the term starts the day that this is issued. It gives the sublimits of the policy, all the particular coverages, and gives all the details about it. It goes on to explain the deductibles, all the different situations which should apply, how it's valued, whether there's co-insurance, talks about where it applies, the forms are listed there, the endorsements are listed there, terms and conditions are listed there. And importantly, you'll note that it talks about the cancellation and payment is for that of the domicile, which in this case is Texas. Nowhere under any of these terms does it describe that New York would be required to file suit there, or that New York law would apply, which is what this clause pertains to. You'll even see a section down at the bottom that then says home state, Texas. So every piece of information, all the information, whether it be domicile, home state, all of that is indicating to the insured that Texas law is going to be applied. Now, why is that important? In this case, there was a storm in March of 2017. And so what you have is the following year, the policy is renewed. They have the 2017, in March of 2016, you filed the claim in April, but this claim is never paid. It takes them 2 years to adjust the claim. They finally make their $5 million in payment in January of 2018. There's no complaint about the amount of payment. There's no a complaint or arguments about the type of coverage. There's no arguments about the construction of the policy. We are content with the $5 million because it's the maximum amount they can owe. What we are upset about is solely that it took 2 years to get to it, because the damage was so catastrophic, it should have been much, much sooner. Go back to the screen. And so, according to the defendant's argument, New York limitations would have ran in March of 2017, almost a full year before they even made their payments. And that's all that this is about. They're trying to get out of the penalties. They're trying to get out of the problems of their late adjustment solely by sending this to New York. Now, unlike the other cases we've talked about, this lawsuit is very different. We're not suing over a construction of the policy or an interpretation of the policy. We're not saying we didn't get paid enough from them. We are suing solely for the statutory interest owed under Chapter 542 of the Texas Insurance Code, or in the alternative, Lockton, the broker who provided us the form we just looked at, they have been sued for not disclosing that this New York law or clause would apply. And therefore, we've said that to the extent that we are barred from these claims, you didn't disclose it to us, and therefore that would be your fault. So Texas has several particular items relating to these issues. And so a lot of the cases that Rachel's been talking about are general ideas that the very general concept, foreign selection clause is enforceable. And to that extent, we're in agreement. But what Texas does is it notes several key policy provisions. The first one we identify is section 101.001A of the Texas Insurance Code. And it notes that insureds in Texas face insurmountable obstacles if they're forced to adjudicate their claims in other states. And the policy language, and the policy in this case, unlike Chandler, unlike the other cases they're involving, is it involves a Texas resident. And the reason why I know Chandler is that was my case as well, Your Honor. That was a few years ago. And what the Court of Appeals came back and said is because it's a Delaware corporation and a Connecticut insurer, New York has just as much interest in this property as Texas does. And so that is one of the key distinctions. 101 did not apply because unlike Wilmax in this case, we have a Texas insured where they're trying to protect under Texas law. But the insurance code goes even further than that. In particular, make sure we have it here, and it is all in our briefing. Section, I believe it is 16.070 of the Civil Practice and Remedies Code is our prohibition in Texas that statute of limitations have to have a minimum of 2 years, routinely enforced. And so even if you put a shorter time period, which insurers often do, they cannot enforce that provision in Texas because of it. And what ends up happening, and what happens here, is our lawsuit couldn't exist. If you dismiss this claim, we try to go to New York, but because it lacks subject matter jurisdiction, because it lacks the ability to go forward on it in terms of limitations, that would result in a dismissal. Now, we still can pursue against Lockton and saying you misrepresented against us, but that's the piecemeal application of it. The second aspect of this, and I kind of got them in both orders here, is that this clause is specifically limited to the construction, effect, and interpretation of the policy. We haven't sued for that. We've sued solely for this enforcement of the statutory interest to which we're entitled. And you can see both from the coverage page that we showed initially, as well as the entire idea that since there is no other enforcement mechanism for it, these are the only protections that insureds have to make sure the carrier can pay in a timely manner. When you read the response, and I think it's contained on page 9 of their response, the whole theme comes out for their briefing. And their argument is, as demonstrated above, dismissal without prejudice of Wilmax claims against First Specialty in Indian Harbor will allow those claims to be pursued in the courts of the state of New York. And their whole gist, trying to get it within the framework of Chandler, is that this is just a forum selection clause. And I go in there, they're not prejudiced anywhere for them because you could litigate it in either forum. That's what's different in Chandler. That's what's different than in these other cases, is that because of these two particular issues, both subject matter jurisdiction and the statute of limitations, that can't be done. And this has changed very dramatically. They have taken this stance because they know, as the Texas Supreme Court held in, make sure I get the case name right, In Re International Profit Associates, that if you're going to send it to a forum that would effectively deny you your day in court, it says you cannot enforce these clauses. That's exactly what they intend to do. Can you pull the other one? So in contrast to the argument in your brief, in contrast to the argument that Ms. Atchison's bringing forth today, that's the other one, please. There you go. Here's the response to our letter. And if you can go down here to where the paragraph reads finally. Is finally, contrary to the suggestion in your June 14th letter that Texas law will govern the resolution of the parties' disputes arising from this claim, please remind that the policy contains a valid enforceable forum selection and choice of law clause, the distinguishing feature from all these other cases, that mandate any suit against First Specialty in Indian Harbor be brought in the courts of the state of New York and governed by New York law, which is in violation of 101.1 and section 2142 of the Texas Insurance Code. Also, you're no doubt aware the policy 12-month suit limitation, which requires any action under the policy to be brought within 12 months after the date on which the direct physical loss or damage occurred, is enforceable under New York law. This is what I lacked in Chandler. And that is that causal link, the same thing that's missing in In-Re Specialty down in Corpus. This is not only the idea that New York law could be applied, it is the specific threat and intent of the carriers to get the case thrown out and denied our day in court, which the Texas Supreme Court prohibits, solely on this basis. With regard to the subject matter jurisdiction, this policy only costs $300,000. And I say only in a casual sense, but that takes it below the minimum $1 million threshold required for New York to do it. And the reason that New York did that is they got tired of companies doing exactly this. New York said, we don't want to have people just simply picking a jurisdiction and filling up our courts with issues that don't matter to us. And so they enacted the statute. Finally, and I think what disturbs me probably the most about this is that not only do we not have notice of it, but there was no way to ever even bring this cause of action, because since they didn't make their payment until January of 2018, according to their own argument, limitations would have ran in March of 2017. So it means it's not simply an issue of when it could have been filed, it's simply that it never could have been filed because the claim didn't become ripe until after limitations in New York had already run. We think these are the impossible situations to be done for, and we think that because the clause does not require the interpretation of the policy itself or the construction of the policy, the clause does not apply. We think the limitations issue, which I've talked about quite a bit, shows that we couldn't bring the action. We think it lacks subject matter jurisdiction. For all those reasons, we think the motion should be denied.
Response.
Yes, Your Honor. The statute of limitations issue is discussed in more than just the Chandler management case, and that came up in AIU and also in Lion Financial Services. Both of those cases have said that just because the statute of limitations have run in the contracted for forum and not the pending forum, that is not enough to overcome the mandatory forum selection clause. I understand there may be some differences with Chandler, but this is the exact same forum selection clause, including
So I understand, and again, the briefing was filed so late by the plaintiff in this case, so I haven't had a chance to digest it at all. This is why we have the 3-day rule, but he seems to be arguing, if I understand it, that in New York, a policy that New York courts will not accept this case because the limits are too low. Is that I guess that's his argument. I'm not sure. Is that correct or not? Or
it's very similar, Your Honor. There is a specific subject matter jurisdiction statute in New York that prohibits choice of law clauses by parties who have no relation to New York. And it's a very specific statute on point. And there's no doubt that we fall within that and therefore it apply. There is an exception within this statute that says that if it's $1 million, the amount of consideration that's being involved, then you can go ahead and do it. In this case, the contract was for $300,000. The policy limits are higher. The amount we actually paid in the transaction is less.
If I can briefly respond. And this issue has been briefed before. Al Copeland was another case that discussed the same issues. This is not a jurisdiction issue, but more of a venue issue. And to the extent that they would want to argue that that statute in New York would prevent filing, that's something for the New York courts to decide. But our argument, I mean, the amount in controversy is well in excess of $1 million. The policy limits are well in excess of $1 million. So we don't think that there would be any issue whatsoever with filing a lawsuit in New York. The bottom line is that the insured per Texas case law is deemed to know the contents of its policy. It was deemed to know that this New York forum selection clause was in there. You can't simply, wait it out and then choose a forum. That just creates forum shopping and is the whole thing that we're trying to prevent. Carnival Cruise Lines have said that even though the clause was not specifically negotiated, that it's still enforceable. If you read our motion to dismiss, it has tons of case law in it that supports the fact that the statute of limitations won't do it. The fact that the insured is located in a different state, there's case law that supports that does not matter. Any inconvenience of traveling back and forth, the connection to the contracted for state, all of those things do not bear enough weight to overcome this presumption. Any arguments that the insured would have on whether the statute of limitations should apply or jurisdictional arguments or any of those things, those all should be before the New York court and not for the Texas courts to decide because of the enforceability of these clauses.
In Your Honor, I think that becomes the exact problem. Let's take hypothetically, if you dismiss the case and we file it up there and then it's dismissed again, we have no remedy. That's it, period. was dismissed for any reason. And that's what specifically the Texas Supreme Court says is a basis for not doing that. But also is the case, is Ms. Atchison was correct. There is a sister case to this where the excess carriers on this exact policy were brought in front of Judge Evans. And we had this issue. And there are some nuances that make these two cases different. Judge Evans denied the dismissal. Judge Evans says it doesn't apply. It went up to the Dallas Court of Appeals. They denied their mandamus. They moved for reconsideration. The Dallas Court of Appeals denied their mandamus again. Now they filed with the Supreme Court. They haven't ordered any party to respond yet. But on this exact same clause, some of which are some of the same arguments, some of which are a little bit different, the motion to dismiss has already been denied under the facts of this case. And again, such a key distinguishing factor that she just glosses over time and time again is the impossibility of ever bringing suit. And the fact that they did not make a payment until January of 2018, 9 months after the applicable statute of limitations would have run, makes the bringing of suit in New York impossible under any circumstances. And that's the basis for denying it. We didn't
Ms.
argue.
Atchison, how do you distinguish what this case from the Judge Evans case?
The Judge Evans case, and we talked about that case in our motion to dismiss. We represent the carriers on both. Those are excess carriers. Those policies didn't even attach until well after the fact. And that is something that we were appealing that case as well, because Judge Evans never gave a reason as to why the motion was denied. He just simply denied it without giving a basis. So in a belt suspenders type of way, we're appealing it without really knowing what the issue was that stuck in Judge Evans' mind. But we are convinced, and we do believe, that it goes directly against the Texas case law that has routinely enforced these form selection clause. That's the only case that has denied a motion to dismiss based on these form selection clause. So it's the outlier here, not this case. And to be frank to the allegation that I'm glossing over the impossibility that they can bring suit, I haven't glossed over that. I've mentioned several cases that talk about the fact that if there's no cause of action in the contract before form in Texas, I mean, that's essentially Mr. Lipscomb's argument, is that if they go to file in New York, that their case can't be heard. Well, if these other cases like AIU, if there's a cause of action in Texas that doesn't exist in New York, they wouldn't be able to file for that either. So all of those issues have been discussed. Everything that Mr. Lipscomb has brought up in his response as to possibly try to say that it would be unjust or unreasonable, all of those things have been discussed by Texas courts, and they've all held that they do not overcome the heavy burden to avoid the enforcement of the form selection clause.
And again,
let me ask a quick question. Okay, so I think I understand it. So the motion to dismiss in the Evans court was denied. You mandamus that denial, correct?
Correct.
And did they say, the Court of Appeals say why they denied the mandamus? They just say that, or do they just not give a reason?
No, Your Honor, no hearing was held. They didn't ask for any briefing or responses. They didn't give a reason why.
All right, obviously, as you can guess, I have to take this under advisement. And Mr. Lipscomb, you have to understand that there's a requirement in Dallas County, I don't know what it's like in San Antonio, to file your response at least 3 days prior to the hearing. I would have been much better prepared for this if you had filed this, so I had a chance to read it. But I'm not going to dismiss the case just because you filed something late. I'm going to take a look at it, but in the future, make sure that you comply with the Dallas County local rules. All right, so we'll take this under advisement. We'll try to get you a decision within 3 weeks. When is your case set for trial?
I think it's a little ways out. I know we have a mediation set in November, so I don't think we have a trial set before that date, but I'm not positive on our actual trial date. Do you know, Rachel?
Raven, yeah, I don't know off the top of my head, but I could.
It's March 2nd, it looks like, so we have some time. Okay, we'll get you a decision as quickly as possible.
Judge Hoffman, if I may, real quick, would it be helpful if we filed a reply to their response specifically addressing some of the issues that that we did not bring up in our motion that we didn't think were.
I haven't read that either, because obviously you filed yours late because he filed his late, which is another reason.
We haven't filed a reply.
Oh, you haven't filed it yet.
So
okay.
I'm asking you if it would be helpful for us to file a reply prior to.
I think it's only fair since he filed late, so you can file a reply and that will end the briefing.
Okay. Is there a
And
certain,
you can have up to 5 pages on it.
okay, 5 pages. Is there a certain date you'd like that filed?
Tomorrow if possible. I mean, as soon as possible.
Okay. Thank you, Your Honor.
All right, thank you. Have a good day.
Thanks.
Okay, I'm trying to see who else is still here. This has been kind of a busy morning. Hardin Ramey, are you here on the Hoffman case?
Yes, sir, I am, Judge.
And then Mr. O'Brien, I saw earlier, but is he still here?
Yes, I'm here, Your Honor.
There you are, okay. But we also have on Miss Pruski. What are you here for, Miss Pruski? Miss Pruski, Cassandra Pruski, are you here for this, for something? And Mr. Rutherford, what are you here for?
Mr. Rutherford's my client, Your Honor. He's observing the hearing.
Okay, and do you know who Miss Pruski is? Or she may be the adjuster, or who's, she's gone, okay. And Mr. Martinez, are you here for something?
No, Your Honor, I was just observing.
Okay. All right, well, I hope you're enjoying it. It's been
This is the best way to learn, so I'm going to watch every chance I get.
Well, it's been a busy morning, so.
Yes, indeed.
So, great. Well, we're here on the Hoffman versus Rutherford case. Do you guys want a record on that?
Please,
Yes, Your Honor.
All right, let's go on the record on cause number DC 1811322, Hoffman versus Rutherford. Counsel, make your appearances.
Your Honor, my name is Hardin Ramey, and I represent Laura Hoffman, the plaintiff.
And I'm Cale O'Brien on behalf of defendant John Rutherford.
Let's go ahead and proceed.
Your Honor, just one thing, if you don't mind. There's a confidential aspect to this case, and I was going to ask you if we can block others, of course, not Mr. Rutherford, or go to the end of your docket, just because we're involving 2 people at the same law firm, and I'm just sensitive about that issue in this case.
Do you want me to turn off the YouTube? Is that what you're asking?
Yes, sir, I guess so.
Does anyone here object to us turning off the YouTube in this case? Any objection?
No objection, Your Honor.
Mr. Martinez?
None, Your Honor.
Mr. Rutherford? Mr. Rutherford, is he your client?
He is my client. No objection.
No objection on his behalf. Okay, I'm gonna go ahead and stop.